I'm going to try to cover a bit of a drive-by shooting to cover various topics with respect to concessions and the allocation of risk. Some of the views are my own personal views. They may or may not be accurate, but hopefully they're provocative to spark debate for the rest of the afternoon. So, in 15 minutes or less, let me start by asking the question, which brings us here today, about what is a concession agreement. That's the first basic question. And as we all know or are about to know, it's basically a contractual arrangement whereby a government, a public authority, grants the concessionaire, the private partner, the right to provide a public service or develop and operate infrastructure for a specified period of time. These typically cover significant infrastructure projects where funding is necessary or there's an absence of funding on the government to be able to do these. They are a form of the other term that I'm sure everybody has heard, a form of PPP, a form of public-private partnership, and many of the ideas that apply to one apply to the other. The terminology, I think, is fairly fluid. They are particularly relevant when it comes to highway projects, railway projects, large infrastructure projects, airports. Concessions, for the history buffs, are not new or novel. They go back many centuries. Just very briefly, I was able to find reference to concessions for canals, for example, were granted in France in as early as 1554. So that's 500 plus years, so not a novel concept. And Muhammad Ali of Egypt in the 19th century utilized concessions to develop infrastructure like dams and railroads in Egypt. So the point here is that concession agreements did emerge as a practical solution for financing and delivering public works, particularly where funds, as I've said, were insufficient or specialized services were required. Now, I think as Hamid indicated, given where I sit geographically, I want to make a few observations about the importance of these kinds of projects, particularly from the perspective of the Gulf. And when I say the Gulf, I mean the Persian Gulf. So the GCC, where some of the numbers are really quite staggering. They are, in the region, they are not as common as in other parts of the world. They have become or are becoming more interesting as the region moves away from traditional oil and gas resources. But it's a region where at least I don't know any place in Qatar or the kingdom that has a toll highway. These are still have been traditionally funded of cash flow because they've had the benefit of the cash flow. But times are changing, as everybody knows. That cash flow is much more restricted than it has been in the past. So there is a move to engage with the market on concessions and PPP type arrangements. So I said the numbers. So here's one number for you, 2023, 2024 MEAD figures. There is a shortfall of not billion, but $1 trillion worth of known, planned, but unawarded projects in the Gulf. $2 trillion, 1.2 trillion of that is in Saudi Arabia. So in short, there's a lot of building to do and a lot of money that's needed to do it. And the other thing that we've begun to see in the Gulf to set the basis for that kind of building is the introduction of legislation, I would say in comparison to Europe and other more mature jurisdictions, much later. It's not till we get to the late 2014, for example, in Kuwait, where there was legislation introduced, and in Qatar and in the Kingdom, it wasn't until 2022 and 2021. So just to put things in perspective in terms of what rides on it by way of value of projects, huge. So let me then turn to risk allocation as such under concession type agreements and ask two basic questions. What do we mean? Well, basically, who's responsible and what happens when things go wrong? And why does it matter? Well, again, that may be a bit of a rhetorical question, but given the complexity of these types of agreements, there's perhaps, as I said, a rhetorical question, but it is something which needs to be emphasized. I'm going to read to you just a short passage. The Global Infrastructure Hub in 2019 asked the Director of General Infrastructure Concession about the importance of these things, risk allocation, and the comment was this: risk allocation is the epicenter or heart of every concession transaction and remains a critical precondition for the successful delivery of every project. Similar view shared by the UN Economic Commission for Development in Europe. Comment is this, which I think brings to the fore the issues. Proper risk allocation and management is the cornerstone to the long-term success of concession-type projects. It is quite simple. If project risks are not formally identified, analyzed, and monitored or controlled, there is a great possibility that the project scope, schedule, and budget may eventually be threatened. I would go one step further and say that it's not probable that if that's not done, that project schedule, scope, and budget are going to be threatened. It will be inevitable that all of those things will be threatened. When it comes to concession agreements, these are like long-term marriage contracts. They're 30, at least for successful marriages, they're 30, usually 30 years or 30 years plus in terms of commitment. And they are, I would think, I can say they're based on more or less 3 pillars. The first is there has to be a sound preparation and institutional readiness. Secondly, fair and efficient risk allocation. And thirdly, predictable yet flexible contractual mechanisms to deal with issues as they arise, because long-term relationships, like long-term marriages, will produce issues that have to be dealt with. So if you're not diligent and you roll the dice, you're likely to be surprised. It reminds me, I'm not sure if everyone in the room is old enough to remember the Flintstones, which I watched growing up as a child in Canada, and there was one scene where there is the mad doctor who's about to zap Fred and Barney, and his assistant Zero says to him, Len, don't do it, release the patient. And the response by the doctor, insistent on proceeding, is, stop bugging me, Mr. Zero, I just have to be a mad doctor. Well, that may be from the Flintstones, but I think it applies in the context of concession agreements, because if you don't do the proper risk allocation and you insist on just being the mad doctor, you are going to get pretty mad results. Results that are good for the lawyers because they produce inevitable endless issues for us to deal with, but it's things that will drive, obviously, countries and will drive private parties absolutely insane. So looking at the second pillar for a moment, in terms of stability in state structures, as I said, governments need to coordinate. They need to be coordinated state actors. If that doesn't happen, the concession process runs out of control. Again, another little statistic to put it in perspective. In looking at some numbers from China between the 1990s and early 2000s, any project that was valued over $30 million had to secure approvals from provincial authorities, then it had to undergo central government review, and then it had to pass through the State Planning Council twice. Not exactly efficient. The result of that process was increased costs, which didn't help the process. Transaction costs in China associated with this kind of process were 10 to 12% of project costs, compared to 3 to 5% in the more developed world. So we can see the importance of there being a strong, rational foundation in place. So the solution, legislation which is enabling, legislation which is robust, and which makes the process more efficient. I want to expand from that not only to China, but to simply say that in other parts of the world, for instance, in second level type economies, low and middle income countries, the World Bank in 2023 said that there was a need of $1.5 trillion annually in infrastructure investment necessary through to 2030. But the attraction of funds was only $76.2 billion in 2021. And that gap, in large measure at least, relates to the weak institutional structures that are in place. So in terms of starting off on the right foot, things, for example, that you need strong feasibility studies, proper disclosure of information so that the bidding process actually works, because if that's not done and the process is compressed, under-resourced, or politicized, that's usually a formula for disaster. We're back to my don't do it Len analogy. We see, for example, numbers again out of this time out of Brazil, where between 2006 and 2016, there were 40 concession-type projects were implemented across various sectors. Of these, 64% of those had to be renegotiated within the first 3 years of signature. It's a staggering number. 2/3 of them had to be renegotiated because of the poor foundation upon which they started. Okay, in the time remaining then, let's get a little more nitty-gritty. And when we talk about risk allocation in particular, what do we mean? The same center that I talked about has produced a risk allocation chart, and the importance is to actually turn your minds for both state entities and private actors to turn their minds specifically to the risks with respect to each individual project. There's no one size fits all, but you need to look at the individual projects and come up with a risk matrix that will look at the various aspects, the various activities, and then you need to decide who is in the best position to actually bear that risk. So there are things such as land availability issues. Who best bears that risk? Social risk, who's in the best position to bear that risk? Environmental risk, design risk, construction risk, variation risk, operating risk, demand risk, financial markets, the list goes on. That needs to be a very, very conscious exercise, put in a risk matrix, written up where the parties actively and consciously turn their minds to those issues to understand who's best to actually bear that risk so that informed decisions can be made. Easy to say, but at least in my observation and practice, it's not done, or it's not done very well, and the outcome, of course, means plenty of work for lawyers such as ourselves. Again, just mindful of time, I want to make now a few quick observations in terms of the dispute resolution process. I am, after all, a disputes lawyer, a back-end lawyer on the dark side. I've given you a whole bunch of figures. Those are interesting, but I want to make a few observations as to the importance of the legal issues. So I'm going to say that in this observation, not everyone is in agreement on the importance of the point, but I think it's important, and it perhaps, and from a comparativist at heart. There's a different approach, and this will come up, I think, in some of the other presentations that will be made, depending on which system of law we're under. Civil law approach versus a common law approach. The common law approach, as most of you will likely know, complete or pretty close to unfettered freedom of contract. It has to be in the concession agreement. If it's not there, you have nothing, more or less. So you end up with agreements that are much longer than those in a civil law context. In the civil law context, they tend to be shorter, but there are a number of implied rights and obligations that legislation ends up filling in. The trend, at least that I've seen, is in the context even of civil law countries for more of those obligations to actually be set out in the agreement, because there is less room then for a debate about interpretation. That's the first point. So when it comes to civil law jurisdictions, as far as concessions and PPCs are concerned, I would say that the more likely to be booby traps, be careful in terms of understanding what is implied by the law in the jurisdiction that you're in, as well as what the contract says. Secondly, there is, of course, the possibility of having other remedies, such as BITs that are in place, bilateral investment treaties, but I would just simply exhort people to say that those are probably something of last resort. You shouldn't bet coming out of the chute that that's where you want to end up. You need to turn your mind to a proper risk allocation in the first place. Thirdly, and given where I'm at, you need to consider, depending on your jurisdictions, for example, in the Gulf, aspects of Sharia, which, once you begin to understand them, are not at all frightening, but you do need to turn your mind to those issues, because if you end up preparing concession agreements that are not compliant, that call, for example, for interest, riba, or call for uncertainty and speculation, gharar, you are going to end up with a concession agreement that is going to be invalid and is going to get you in all sorts of trouble. So there was also the concept, for instance, of hardship that was mentioned earlier today, a concept that has existed in the Gulf for a good long time. It's a concept that exists under Sharia. It has come into application, at least under the French Civil Code, as between private parties, I think only as recently as 2016. But it's not a provision that you can contract out of. It's not like force majeure. You, whether you like it or not, you're stuck with those provisions, which means that in situations where there is an imbalance that results as a result of an event that was truly unforeseeable, there will be ultimate jurisdiction and discretion in the courts or the arbitral tribunal to rebalance the interest of the parties to come up with a fair solution. The common law lawyers, that usually sounds quite frightening, but in practice it actually works, in my experience, really well. Finally, in terms of multi-tier dispute resolution provisions, I will simply say that I'm quite skeptical of those. At least the multi-tier approach, in my experience, the streamlined approach tends to work better. In other words, yes, it's okay to have an initial phase where there's some discussion between the parties before they get to the main event, but if you end up creating a whole bunch of obstacles, potentially conditioned precedents, they create a problem. And last but not least, you need to make sure and be careful that you are complying with all the formalities in the forum that you've selected in terms of the ability to use foreign law or, in fact, arbitration. We have legislation which, interestingly, I'll read you this and I'll close with this. So the PPP legislation in Qatar that was passed in 2021 says this in Article 28, the partnership contract shall be subject to the provisions of the Qatari law, and every agreement to the contrary shall be void. So if you try to contract, you have a concession agreement and you try to contract out of local law, contract is void. Secondly, and very interestingly enough, can you go somewhere other than the local courts? The law says this, the Qatar courts shall have jurisdiction to settle disputes arising out of the contract between the parties. The contract may include another mechanism for setting aside disputes upon the Prime Minister's approval, based on the minister's, and that would be the Minister of Commerce and Industry proposal. Two conditions that you have to satisfy yourself. So if you have somebody, you're in Qatar, and this has been litigated, and the results can be surprising, and it's a state entity that signs up to arbitration, you need to ask yourself the question, has it been approved by the Prime Minister? And if it has, was it recommended to him by the Minister of Commerce and Industry? And if you can't actually paper that, you run the risk that you're going to end up in the domestic courts as opposed to arbitration. So, the long and short of it, if you're going to do it, then, and not release the patient, you'd better fully be aware of what you're doing. Diligence, diligence, diligence. It's painful, but if you don't do it and don't do that proper allocation of on the front end, you will come the back end, have plenty of surprises to deal with. And thank goodness for those kinds of surprises, because it keeps people like us in business, and I'm sure it will continue to keep us in business for a very long time. Thank you.